For those who are interested in what's going on in the Datuk Sri Najib's submissions at the end of the defense case in court, here is an interesting development. In the course of the submissions last week, the learned judge, Justice Colin Sequeira, interjected into the submissions by the defense and posed a question. Is there any evidence that Shahrol benefited from all the things that he has done? Is there any evidence that Shahrol benefited? That's the question posed by the learned judge. Now, at the outset of today's continuation of submissions, Defence Counsel Dato' Tanyas Chivati had answered the inquiry made by the learned judge. Now, I would like to read some of the response given by Dato' Tanyas Chivati. The evidence shows that Jolo was the person who had prior working relationship with Shahrol long before 1MDB. In fact, Jolo was Shahrol's client during his time at Accenture. It was Jolo who recommended to Shahrol. It was Jolo who recommended Shahrol to Tunku Mizan, the Sultan of Terengganu, for him to be appointed as the CEO of 1MDB, a recommendation that changed Shahrol's career and his financial circumstances overnight. Following the recommendation, Shahrol's fortunes transformed. His monthly salary increased more than threefold, from 30,000 a month at Accenture to 99,000 a month at 1MDB, together with perks, a driver, and directors' meetings allowances. In real terms, he went from earning 360,000 a year to approximately 1.2 million ringgit a year, with additional perks and meeting fees. And that's not all. In addition thereto, Shahrol received a signing bonus of RM 160,000 when he joined the Terengganu Investment Authority, which became 1MDB. And because of Jolo's recommendation to Tunku Mizan, Shahrol became the CEO of a sovereign wealth fund, a prestigious position that elevated his standing overnight. Now, as the CEO of 1MDB, he went on to receive bonuses in the millions, far beyond what he had ever earned before. Even when he was seconded to Pemandu, Shahrol continued to draw his full salary from 1MDB, despite no longer serving the company directly. At this juncture, the Defence Counsel submitted. It is precisely at this point that the law becomes relevant. Under Section 3(b) of the MACC Act, employment and all benefits arising from it falls squarely within the definition of gratification. So the very position that Jolo secured for Shahrol, with its salary, perks and prestige, constitute a form of gratification in itself. One need not receive benefits that are easily traceable. We cannot know if Shahrol received cash or other valuables from Jolo, which could easily have been stashed in safety deposit boxes placed under other names. The point is, the absence of documentary proof does not mean the absence of benefit, as employment qualifies as gratification under the law. From the defence's submission so far, it is clear that Shahrol was not a neutral witness. He was an interested one, and support for this is found in the evidence before the court. SAC Raja Gopal found that Shahrol has committed criminal breach of trust, and Number two, 1MDB itself filed a civil suit exceeding billions of ringgit against him for his wrongdoings and negligence. Also, the court had the benefit of hearing from Shahrol's own testimony, which was supported by SAC Rajagopal's findings, wrongdoings and negligence. Shahrol, without any reservation, confirmed he merely signed documents that were brought to him. Yet the evidence shows from those very signatures, he moved billions of dollars, but not all into 1MDB's projects, but also into Jolo's pockets. Now, focusing on the USD 1.63 billion that was misappropriated, Shahrol admitted signing 2 collaboration agreements and 2 remittance instructions, under which a total of USD 1.63 billion was transferred to Aba Investment PJS Limited, and he did so without any board approval, without those transactions being mentioned anywhere in the offering circular. At the material time, he was the CEO and a director of 1MDB and several of its subsidiaries. Yet he signed those agreements and remittance instructions without protest. The documents, he said, were brought to him by Jasmine Lu. Jasmine, as the prosecution's own witness, and Hazim, another witness, confirmed was that Shahrol was Jolo's proxy in 1MDB. Notably, Hazim never said that Jasmine was Datuk Seri Najib's proxy. Shahrol knew Jasmine even before joining TIA and before she joined 1MDB. They both had served Jolo, Shahrol as his consultant at Accenture and Jasmine as his private lawyer. SAC Rajagopal's investigation revealed that by Shahrol signing those documents brought to him by Jasmine, Shahrol misappropriated USD 1.63 billion of funds belonging to 1MDB. Even apart from SAC Rajagopal's findings, Shahrol's actions were grossly negligent as found by the Public Accounts Committee. Naturally, therefore, he has every motive to shield himself from prosecution and civil liability. Now, put this in perspective, Jolo secured for Shahrol a prestigious CEO position with a salary of 99,000 a month, plus perks, director's fees, and even a signing bonus of 160,000 when he joined. In return, by Shahrol's signature alone, Jolo benefited enormously, receiving US dollars 958 million in 2012 through Aba Investment PJS Limited, which in turn was transferred to a company connected to Jolo. And this USD 958 million came after Jolo had already received into his Good Star account USD 700 million in 2009 and USD 330 million in 2011. And this is made possible because Shahrol signed the remittance instructions to Good Star. In total, therefore, by 2012, Jolo had gained US dollars 1.988 billion, nearly $2 billion, through Shahrol's hand. Yet the prosecution asked this court to accept their narrative that Jolo was Datuk Sri Najib's mirror image. In that, it means that whatever that Jolo does, in fact, was done at the behest of Datuk Sri Najib. So whatever that Datuk Sri Najib wants is carried out by Jolo. That's what is meant by the prosecution, that Jolo was Datuk Sri Najib's mirror image. and that Shahrol was merely acting on Jolo's instructions because he believed those instructions originated from Datuk Sri Najib. Let us entertain that narrative for a moment. According to the prosecution, Datuk Sri Najib allegedly received about 50 million USD between 2009 and 2012, which Datuk Sri Najib contends that was a donation pursuant to the pledge made by King Abdullah. The defense has submitted that there's no evidence directly linking the USD 50 million to 1MDB's money. So at best, the prosecution's case was that 50 million USD was taken by Datuk Sri Najib. And yet, in the same period, Jolo, Datuk Sri Najib's so-called mirror image, received USD 1.988 billion. Is this possible? Could a mirror image earn 1.988 billion as opposed to the main player who only gets USD 50 million during the same period? That is why the defense has answered his lordship's inquiry by saying that Shahrol has certainly benefited. He has benefited by getting himself a new position that entitles him to get a higher salary, perks, bonuses, and he is beholden to Jolo, and that everything that he does not do it because he thinks that it was Najib Razak's instruction. He did it because it was Jolo's instruction. While the prosecution would have this court believe that Shahrol was a dutiful subordinate acting under under others' influence. I'll do that again. So while the prosecution would have this court believe that Shahrol was a dutiful subordinate acting under others' influence for the benefit of Datuk Sri Najib, the facts tell a different story. Shahrol was a willing participant and a beneficiary of Jolo's design, and he has every reason now to protect himself from prosecution, from civil liability, and from the consequences of his own action. That is the answer that was provided by the defense to the inquiry made by the learned judge.